We're so grateful. Community Development Corporation, LITE, is sponsoring. You know, as the senior pastor of the church, it's my endeavor to make sure that we as a people of God get all the information that we need to strive and survive in this life. I'm grateful tonight to have our presenters, as Dr. Crockett will introduce them later, but I'm certainly grateful to have them with us and to share with us information that I know will be vital to the people of God, to the members of our congregation, and to several other congregations that are joining on tonight.
Thank you very much. We're going to get started. I'm going to introduce Judge Karen Brown, and then she's going to introduce the panel for this evening. Judge Karen Brown.
So thank you for giving us this time, and hopefully you'll be blessed by the presentation tonight. As Ms. Crockett said, my name is Judge Karen Brown, and I'm going to be serving as the moderator/facilitator this evening for this seminar on estate planning. We have the honor this evening of being joined by the Honorable Bernice Toledo. She is the judge of the Surrogates Court of Passaic County. We are also joined tonight by my distinguished fellow colleague, attorney at law, Connie Bentley McGee. So I want to thank the both of them for their time tonight, and I'm very excited to have them with us. So before we get started, I wanted to give them a few minutes to introduce themselves. So for people that, you know, may not know them or may not be familiar with their background, I wanted to take a few minutes to have them introduce themselves to you before we get started. We'll start with Judge Toledo.
Well, thank you. Thank you so much to Judge Brown for having invited me to participate in this. Thank you for the opportunity to speak to the Christian Fellowship, and I congratulate you on being so forward-thinking in empowering the community to know how to take care of their affairs, how to defend themselves, how to plan for their own futures going forward. Knowledge is power, and that's exactly what you're doing for your congregants, is empowering them to be able to handle what life inevitably hands us. So who I am, I'm the judge of the Surrogates Court. I've been acting in the capacity of the Surrogates Court for about 10 years. So I'll reach the decade mark this year. It's been a wonderfully gratifying time. And unlike other judges who are appointed, for example, Judge Brown was appointed by the mayor, a Superior Court judge is appointed by the governor, but I am elected. And what's the difference? Well, the difference is the Surrogates Court, as the name implies, the surrogate means one who does for another. The Surrogates Court empowers people to make legal decisions for those who cannot, one who does for another. So those who cannot aren't able to vote for that mayor that makes the judicial appointment or for that governor that makes the judicial appointment. So we empower the spouses, the adult children, the people in the community to decide who will give a voice to the voiceless. I serve in a variety of capacities. The main capacity and the main thing we do is handle matters of the deceased. So that's a person who had a voice. Their voice is now gone because they've passed away. But guess what's not gone? Their car is not gone. Their house is not gone. Their bank account is not gone. So they have to come to the Surrogates Court for assistance to empower them for a court order. The other areas where I help are matters of the incapacitated. So think of a grandma with Alzheimer's who has a legal voice, but her voice is starting to dwindle as life goes on. Or think of somebody who's had a lifetime challenge with autism or with Down syndrome, where their legal voice never quite turns up because they don't have capacity. So I handle matters of the deceased, matters of the incapacitated. I also handle matters of the filings for the orphan child. So all adoptions in the county of Passaic come through the Surrogates Court. We're the only game in town. So if you're adopted in Passaic County, it has to be filed in Passaic County, and then it's heard on the state level. I'm on the county level. With respect to what we do and what we've done, so the bulk of what we handle are matters of the deceased. And what COVID gave us was more deceased people than we have seen in forever. I can tell you in the last 10 years I've been there, we lose about 3,700 people a year to standard things, heart attacks and cancer, things like that. On any given month, we lose about 300 people, and that's normal in Passaic County. In April of 2020, we lost 1,320 people. It was a 400% increase in deaths in April alone. By the time the end of the year came, instead of having our usual 3,700 deaths, we had about the numbers aren't completely in yet, but it looks like it's going to hit about 5,400, 5,500 people. So it's a 50% increase overall, taking into account those really high months of April and May of last year, of 2020, because of the pandemic. What I can tell you is the courthouse doors are physically closed, but we are fully staffed 8:30 to 4:30, Monday through Friday, because if we can't serve now, when you most need us, when can we serve us? Now's our time to shine. We're here to serve, and we're at your service. Thank you.
Thank you, Judge Toledo.
Hello, everyone, and thank you so much to the Christian Fellowship Center and to those of you here in Bible study tonight for actually giving up your time tonight to listen to us. And of course, I thank my good friend Karen, and I so appreciate meeting you, Judge Toledo. I've been an attorney a long time, and by long time, I mean almost 40 years. How did I come to this area of probate or interacting with the surrogates court? Well, I came by way of being a public defender. Judge Toledo spoke about the surrogates court being a voice for others. Well, I was a voice for those who were criminally charged. And from the public defender's office, I entered into private practice. And I still maintain a practice in the neck, well, I call it the neck, but in the ironbound section of Newark, okay? And I continue to practice criminal law, and I also practice as a prosecutor in several municipalities in Union and Essex County. I came to this line of work about 15 years ago because my mother became very ill, and I rushed home to Indianapolis, Indiana. We thought she was dying, and in fact, she did die several days after I arrived home. But what struck me is how around her bed we're all arguing, quote unquote, about what to do in terms of whether we take her off the respirator or leave her on it. And out of that, we did reach a decision. But what I learned later is that my mom actually had a power of attorney. As the attorney in the family, I knew nothing about it. My father knew, my two sisters knew, but the other four siblings, we had no clue. Had we known about that power of attorney, we would have known also what her healthcare wishes were. They knew, but we didn't. And so from that, I learned that it's really important that whatever healthcare decisions you make, however they're reduced to writing, whether it's a power of attorney or, a letter, that you actually inform the people closest to you and your doctor. Even her doctor didn't know that this power of attorney existed and that she actually had certain healthcare directives that she had made that were included in that power of attorney. So from that, I just started to look at how we communicate with one another and how really in a time, especially like COVID, and we're all not getting younger in a sense, that there is a need to have something in place in order to continue and to make sure that we maintain health. So that's why I actually do this. I enjoy helping people and I enjoy assisting people in making sure that whatever their decisions are regarding their assets, that those are actually carried out. So as a lawyer, that's how I'm able to be of assistance in this area. And I appreciate you for having me here. So thank you.
Thank you, Connie. Like Connie and Judge Toledo didn't get into her public interest background, but she has an extensive public interest background as well. I was born and raised here in the city of Patterson, and based on my experiences here, I decided that I wanted to empower my community And I felt that going to law school would do that. I started out as a public interest lawyer at the former Passaic County Legal Aid Society. I was working with public housing tenants at the time that my mom was a public housing tenant, and she was being relocated as a result of the housing developments being demolished. So I got out of law school and I got an opportunity to do a fellowship to help public housing tenants. So I did that, was grateful for that opportunity, which ended up being recognized by President Clinton for that public interest work. And then I transitioned over to county government, and I worked as an assistant county counsel and the county adjuster at that time. And then I was drafted at the age of 30 to run for public office, which I did. And I was elected to the position of county clerk. I served in that position for 5 years. Then I was asked if I was interested in becoming a municipal court judge. And I was, because I felt that it was important for people to see people that look like us on the bench. And it was a great opportunity to serve my hometown. So I ended up becoming a judge in the city of Patterson. And then several months later, I was approached about becoming the chief municipal court judge in Passaic. So I held those two positions. I've also served as the corporation counsel for the city of Newark. I've served as the borough attorney for the borough of Roselle, served on various boards and commissions in the city of Patterson and the county of Passaic. So I've had the opportunity to be involved on that level as well. And I'm currently now in private practice. And I actually started my private practice when I was an assistant county counsel, because I was approached by someone who wanted me to help them do an adoption. So that involved the surrogate's office. I knew nothing about the adoption, but my boss actually came to me and asked me if I could help. So my private practice actually was born out of having a desire to help people. I've done that, since that time. I incorporated my law firm back in 2004, and that practice includes drafting simple wills and things of that nature, and helping in other areas such as criminal law, municipal law, real estate matters. I'm also currently a contractor for NYU Langone Health, which is a premier health organization that consists of NYU Langone hospitals as well as their medical schools. So I double in that capacity, and I'm glad to be here this evening. So the topic of estate planning. Now, estate planning, as many of you may or may not know, it's really about deciding who gets your assets when you pass away, but it's also about how you want people to handle your health and financial decisions if you are unable to do so for yourself during your lifetime. So let me take an opportunity to see if I can share my PowerPoint presentation with all of you. There we go. So why is estate planning important?
Can I jump in on that?
Couple of weeks.
It is so very important. And let's start with the topic that was discussed by my co-panelist. For one, it preserves family unity. So if you want to make sure that those Thanksgiving dinners remain intact after you pass away, you have to have good family planning, because everybody has an opinion. Everybody thinks they know what's best. And no matter how great their intentions are, it can cause a lot of discord because there are different interpretations. Mom said this, mom said that, and it can cause a lot of discord. Another reason why is you have to discuss these things and plan accordingly, because you don't want to hurt your loved ones. And I will give you an example. Let's talk about Medicaid. I knew a woman, this is right around the time I became a surrogate, but it related to a different county. She was a neighbor of mine. She was 60 years old, and her beloved father, who adored her so much, left her $15,000, $15,000. One would think that's wonderful, that's a windfall, right? It wasn't. What happened was, in receiving that money, she became disqualified for Medicaid. She lost her home health care worker. She lost her health benefits. She had to spend down the $15,000. She was put on a waiting list for a bunch of programs. It put her life into a tailspin for more than a year. So you have to plan, you have to speak to an attorney, you have to understand that the decisions you make no matter how noble they are on your part, have implications for the recipient. So if you have somebody who has special needs in your life, let's say somebody with Down syndrome who receives Medicaid or social services or something like that, you have to be very careful as to how you plan for their future. You can't just give them money outright. Either you put it in a special needs trust or you exclude them outright from your will. But you have to be very careful in making sure that you don't give them more money than what is allowable by those programs. And for Medicaid, you're talking the $2,000 range. So you can easily exceed that. So number one was to preserve family unity. Number two, to assure that you don't hurt somebody financially. Number three is because it has tax implications. So you have to plan to make sure that the majority of what you give is appropriately given to the proper beneficiary for which there will be the least tax implications. So there are different kinds of beneficiaries. There's a Class A beneficiary, which would be a spouse, a grandparent, a parent. There's a Class B beneficiaries are gone. They were gone in 1960s, but there's a Class C, which is a sibling. And then there's a Class D beneficiary, which is like everybody else. So a nephew, a beloved nephew, and the shoe shine guy all stand in the same shoes with respect to how they're taxed. So you have to make mindful decisions to make sure that it passes in a way where you can preserve more of it and limit the tax consequence. Do we agree on that?
Yes, absolutely. And to add to that, in general, it just makes it easier for your family to ensure that your needs and wishes are met if you're unable to speak for yourself, whether you're dead or you're incapacitated. And this is a subject that I understand that it's not a fun subject to talk about. None of us really want to think about, dying or becoming incapacitated, but it's inevitable. Having a will in place expresses exactly how you want your estate administered. Your desires are what counts. It's your ability to control who gets your assets. It's your ability to make sure that your assets are distributed in the way that you deem fit. You get to choose who gets what. You get to choose whether or not you want to make special gifts to friends or family members. You get to decide whether or not you want to make a contribution to your church or another institution. You get to decide who you want to be in control of your estate once you're gone. There's also financial implications when you plan, like Judge Toledo said. You get to avoid certain types of taxes. You get to have your executor not have to pay a bond. So there are many, many, many benefits of having an estate plan. And without it, you have no control. Property in your estate may end up in the wrong hands, and people that you want to inherit or to benefit from your estate may not necessarily be able to do so. You also get a chance to protect minors. If you plan, you can name a guardian in your will for minor children. You can also name someone that could be a trustee in the event that you want to pass along assets to a person that is a minor. So those are all some of the benefits of estate planning. Our surrogate did give an overview of her office early on in the presentation. I don't know if there's anything else you would like to add.
Just simply what people should keep in mind is you should envision the surrogates court as the last responder. So we come after the funeral, or after the ambulance, after the funeral, after everything. We are the ones that are there to free up your assets so that you can pay for the burial, so that you can free up assets and do it with as little, barring any objections, of course. But if there are no objections and things are in order, to do it in a way that is efficient and with the least red tape, so that you can go on to doing what's important, which is honoring the memory of your loved one, which is grieving, which is doing all that. But, the first step is getting through us so we can free up your assets and you don't lose them to the fact that you have a house that's tied up, but nobody can enter it and pipes are bursting and winter is coming, or a car that you can't get towed. You can't sell it, you can't tow it, you can't junk it because you have no title. So as let's call us the last responder, we're there at the very end to help tie the loose ends for your family and your loved ones.
Connie, did you want to add anything?
Yeah, I just wanted to add, you can give away whatever is of value to you. If you've got that favorite recipe, if your relative happened to be the owner of Popeye's chicken sandwich, take that recipe. It's a secret, it's a family secret, and hand it down. Whatever it is that's of value to you, you ethically can give it away. Okay, so let's not always think in terms of houses or cars, because people tend to think that way with money, stocks, and bonds. But whatever is of value to you, you can give away.
A lot of people I speak to don't think that they need a will because they look at estate planning as something being for rich people. And that's not necessarily the case. If you own anything that can be turned into cash, they're considered to be a part of your estate. And you can direct how you want those assets disposed of. And even when we're talking about the rich, sometimes they don't have their affairs in order. If you look at Prince, the millions of dollars in value of his estate with all his copyrights, everything, he did not have a will. His siblings are now in court fighting, and I have a friend that's actually representing one of his siblings in these fights over his estate. Can you imagine the costly legal fees that are entailed just because he did not have a will? You look at Aretha Franklin, years in court now, battling over her estate because they could not find a will. So it's not just, rich people who, they should, you would think, but sometimes they don't. It's very, very important. We'll walk you through and you'll see how simple and easy the process is. Let's talk about the will. Obviously, that is the biggest one in terms of controlling your estate after you die. You have trust that can also be established. Power of attorney, and again, we'll talk about these documents in detail a little later on as we go along in the presentation. And advanced directives for healthcare. These are all estate planning documents that are going to help you while you are here on this earth, as well as when you pass away. So let's talk about will, which is usually referred to as the last will and testament. Some of the requirements. It's a written document that spells out how you want your property and assets to be distributed after your death. The persons or institutions named in the will to receive your money, property, or other assets are called the beneficiary. The will also sets out who the executor should be. The executor is the person who's responsible for settling the estate and carrying out the terms of the will. Now, we should probably talk about how important the executor role is and what kinds of things you should consider when you're choosing an executor. You really should choose someone that you know is responsible, that you can trust, because it's a job. If you like someone and you trust them, but they don't have enough time to do to do certain things, that's not the person that you want to be the executor. You want someone that's very, very responsible, because they're going to be responsible for administering your estate, which means that they have to pay any outstanding debt, they have to file certain tax forms, and they have to distribute the property and assets in your will as you direct. So you want someone that's trustworthy and you want someone that's responsible. I don't know if any of our other panelists want to chime in on the executor role.
I want to talk about the reluctant executor, okay? Because I have a situation where I have a very responsible person, two of them. One's the first I'm talking executor, but these people are also holders of a power of attorney, and they are reluctant while the party is alive to even handle those responsibilities. So I have some misgivings as to whether or not they're really going to be able to do the job or want to do the job as an executor, because as you said, it takes a lot of time. And I'd like to see something put in place while the person is alive so that certain expenses will be taken care of and the executor won't be placed in a position of not knowing what's going on or how to handle financially everything that comes up. So that will has to really be, I'm going to say, specific on how expenses are to be paid for during the afterlife.
So with respect to an executor, executor comes from the term execute. You are executing the wishes of another, right? So you can only have an executor when you have a will because you're executing the wishes of another. That's how you see on TV, so-and-so left $1 million to the parrot. The law would normally not allow that, but if you have a will and those are your last wishes, then the executor is executing, and it's executrix, by the way, if it's female. The executor is executing the wishes of the decedent. With respect to an executor, you should always have a contingency. So with respect to the reluctant executor, you have to have a plan B. So my executor is Jane Smith, but if she is unwilling, if she is unable, if she serves but then resigns, then I nominate Bruce Smith. You can nominate a second person, a contingency. In case plan A fails, you have plan B. Having an executor is very important for a variety of reasons. And it's not only when you have assets, it also includes, let's say you have no assets, but you pass away in a wrongful death, in a car accident, in an accident at work. For you to file a lawsuit, or for your estate, because now you're no longer with us, your estate to file a lawsuit to make your family whole, because now your family has been left behind without you, you need somebody to step in your shoes. If you have an executor named in your will, even if you have no assets, it's very important that you nominate that. Now, remember, it's a nominee at that point. They're not executors until they are determined to be so, until a judgment is entered by the surrogate's court, by the judge of the surrogate's court, in this case me, accepting that nomination. So it's very important that you have them there, and to take care of the reluctancy in scenario, you have more than one.
And so, Judge, may I ask you, what happens if there is no one left? What does the court do?
So what happens is this. So let's say you have your will, and your will leaves $1 million to the parent, and you leave your car to your best friend, and you do all these things, and you name Mary Smith as your executor. And there are no more executors left. Then it becomes an administration, they call it CTA, I won't get into technical terms, with the will annexed, which means your wishes must be preserved, but it will not be done by an executor. An executor is the person you've named. It'll be done by an administrator who's still acting in accordance to your wishes, but it won't be the person you named. What's the difference? The difference is they'll have to be bonded, because we don't have a bonded means you have to take out an insurance policy for which you must qualify to assure that you do the right thing, because we don't have the deceased person telling us, I trust Mary Smith. Now it's whoever's entitled. Who's entitled when you have a will? I'll use a fancy word, the residuary legatees. So basically, somebody with an interest in the will, somebody, maybe you know, the caretaker of the parrot, the neighbor who was getting the car, those are people who are going to receive under the will. So they are first entitled to serve, so that they can make the application to serve, which may or may not result in an appointment. And when I say it may result in an appointment or not, that means it comes through me, and I determine whether the appointment would be appropriate and whether notification has been given to all the parties in interest. There's always a way. You know, New Jersey is actually very user-friendly. People are always saying you have to avoid probate, and probate is horrible and it's tedious. It is in some states, not in New Jersey. In New Jersey, the cost is a couple of $100s to probate, if that, depending on the size of the estate and how complex it is. and assuming that nobody's fighting. I mean, once people start fighting, once people start fighting, it can turn to tens of thousands of dollars, but, or even more than that. But assuming that there's agreement again for who's going to serve, or there's a will appointing somebody to serve and the will is in order, then it's a pretty straightforward process. It's a pretty low cost process. You should make sure that your will is looked over by an attorney like Ms. McGee, like Judge Brown, who are experienced in these matters, because sometimes when you download these wills from online, it does more harm than good.
That's very important. So the lesson in all of that with regard to people being hesitant is to have a conversation with someone before you sit down to do your will and name them as an executor. 2 weeks ago, I had someone send me a draft of their will and say, hey, look at this, conform it to the legal requirement, and they had me named as the executor. And I felt some kind of way about that because I don't want that responsibility. I don't know you like that. So I don't want to take on that responsibility. So I had to tell them, look, you know, like you, I'm honored that you asked me, but I'm not really comfortable serving as your executor. So it's important to have that conversation before you draft your will. Your will, you can also name a guardian, provide for a guardian to be named when you have minors. You can also appoint a trustee to manage any money that you leave them, which is what I indicated in the beginning of the presentation. You can also establish a trust where assets can be put in a trust for your care while you are alive. And I don't know if Connie and the surrogate can talk a little bit about trust, but that is also a mechanism that you can use, and you can also make that a part of your will.
You mentioned trust, and that may not be something that most of us are familiar with, but certainly just the word itself, you know that a trust can be created. It's an entity into which you place your assets. And your assets could be anything tangible. It could be your house, your car, it could be your money, your stocks, your bonds. And over that trust, you have a trustee or a person that you believe would be trustworthy and responsible enough to manage those trusts. I see it as a way to avoid the probate court, because probate is public, and whatever you submit to the probate court, your will, that becomes public information. A trust, once the documents are created and the trust is funded, or I'm using the word funded to mean whatever you put into it that you want protected, that actually is the end of it. And as I understand, there's nothing else legal that has to be done to make that trust effective, other than, of course, making sure Uncle Sam knows about it. So before you even open it, you better get that tax ID number for this entity that's created. A trust, I think, is more difficult to contest than a will. Certainly with the will being public, other people can come in and perhaps contest it for whatever reason. A trust is not that widely known, probably just to the people that you've shared it with. So I think that as a part of an estate planning vehicle or package that you want to put together, a trust is certainly something to be considered. And it's to be considered with perhaps a financial planner, a tax attorney. It has to be considered in terms of any tax complications that might arise. You certainly have a revocable trust. That's one where you revoke or take back the powers of the trustee in managing that. You can also have an irrevocable trust where you take yourself out of the equation and everything is placed in the hands of someone else, so that that control over that trust is no longer yours to have. And that's important too for tax consequences. So those are things that you can discuss with your attorney, your CPA, your financial planner. You know, we all work together on helping you decide the best vehicles for you to take.
Judge Toledo, anything you want to add?
No, she pretty much covered it. Judge Brown, you had mentioned something about naming a guardian for your child. You should keep in mind, though, that when you name a guardian for your child in a will, that is a testamentary guardian, and it is persuasive to the court, but not dispositive. So what does that mean? That means if you named Aunt Jane and Uncle Zeke objects to it, he will, he will take it to court, and the court will review Aunt Jane to see, if she's fit. Will entertain Uncle Zeke's arguments, and it will be persuaded by the fact that you had enough trust in Aunt Jane to serve. But if they scratch beneath the surface and see that she has subsequently become unable to serve, either because she is unwilling, she's unable, she's sickly, she's passed away, she has a substance abuse problem, whatever it is, if she's somehow not fit, then the court will do, as always, what the best interest of the child is. So it is persuasive, but it's not dispositive. So you should just keep that in mind.
Okay. Thank you, Judge Toledo. So a couple of other things that can be included in the will. Sometimes people can include specific funeral arrangements. I've had it where I've had clients spell out exactly how they wanted their funeral, where they wanted to be buried, whether or not they wanted to be cremated, down to what outfit they wanted to wear. So you can be as specific as you want. But yes, there have been instances where people have included funeral arrangements and special requests, like I indicated in the beginning. Gifts to charitable organizations, gifts to people. I mean, was it Imelda Marcos that created like a $15 million trust for her cat? So things of that nature, special requests. Yes, those are things that you would name in your will. It's important to understand what property is subject to a will. A lot of people sometimes get confused as to what they can convey in their will. So you have to take an inventory and determine, and there has to be a distinction between what's considered probate property and non-probate property. Probate property is the property that's owned by a decedent alone, solely, or as a tenant in common. A tenant in common means that they own something in conjunction with someone else, and when they pass away, their share goes to their estate. So that type of property is property that can be passed through a will. Non-probate property are usually, it's usually assets or property that names a beneficiary. Life insurance policies, retirement benefits, joint property, property that's held in trust, and property that payable on death accounts. So these are all types of property that's not controlled by the will. So they pass outside of the will. They have designated beneficiaries. So it doesn't matter what your will says about who should get your life insurance proceeds. What controls is the beneficiary. So you have to make a distinction between what is considered probate property that passes under the will and non-probate property. The only time life insurance is considered probate property is if you make your death benefits payable to your estate. There's some, people say there's good and bad things about that, but we won't get into the nuances of that. But typically, anything that has a beneficiary designation is considered non-probate property, and it passes outside of the will. So if we go to the next slide, we'll give you some examples of what probate property and non-probate property looks like. So probate property can be tangible or intangibles. Real estate, works of art, cars, jewelry, things of that nature, probate property. Intangible, cash, stocks, bonds, all of these things, anything that can be turned into cash is considered probate property. And Judge Toledo, I don't know if you also want to, chime in, and Connie, in terms of, the importance of that distinction and maybe some, additional examples, anything that you want to add to this distinction.
Yes, so there's some things that pass by operation of law. There's some things that pass outside of the estate. And that's how this works. When we're discussing a house, for example, and we see this often with a husband and wife or with a set of spouses, where the deed says, spouses with right of survivorship, right? So when one person dies, there's a right of survivorship. So that house is passing outside of the estate, depending on the deed. If two people, let's say two brothers own a house, that house is not going to pass outside of the estate. 50% of that house belongs to the one brother and it'll go to his heirs. So do you see the distinction where in one instance it will pass automatically outside of the estate? If that's the only asset, you don't need the surrogate's court. But if it's two brothers and there's no right of survivorship, when the one dies, that 50% value of that home is part of the probatable assets. With regard to a car, for example, if the car is in your name, but before dying, you sign the back of that deed to somebody else, that passes outside of the estate. And this is rare, but sometimes people have the car deeded jointly with somebody else. That could pass to somebody else outside of the estate. So you say to yourself, well, if there's no will, but I have a payable on death in my bank account, will it pass without the surrogate's court? Sure, it'll pass. The question will be, will it pass to the right number of people? Let's say you have 3 children and you have one payable on death, it'll go to child number 1. What about child number 2 and 3? And you have to consider those things as well. But there are ways that your assets will pass with things like beneficiary designations. One caveat, one warning is you have to look at things like your life insurance policy, your pension benefits, any policies you have to work regularly. I have seen instances where there's a particular case I'm thinking about where this gentleman dies. He worked at UPS for I don't know how many years. When he first started, the girlfriend of the hour was named as his beneficiary. And then he dies 20 years later. Nobody knows where that girlfriend is. He never updated his beneficiary designation. Meanwhile, he has a sister alive who had to pay for his funeral costs. So be sure to look at your beneficiary designations regularly. If you have no beneficiary designation, it will go to your estate and it'll go either in accordance to your will, and if you have no will, in accordance to the laws of intestate succession. We'll discuss that later, intestate succession.
Thank you, Judge. The judge mentioned non-probate property, like life insurance policies, retirement plans, as she said. Make sure that your beneficiaries are updated. Doesn't matter what your will says. It matters who your beneficiaries are, who are designated in these policies and plans. So make sure when you have a major change in your life that you update your beneficiaries, or just periodically make sure that you're checking them and updating them so that they do what you want them to do. Now we're getting into what the legal requirements are for a will. Must be 18 years of age or older. You must be of sound mind. Your will should be in writing. It should be signed by 2 witnesses over the age of 18, and they should be of sound mind. And your witnesses are not reading your will. They don't need to know what exactly in your will is or who your beneficiaries are. Those witnesses are simply witnessing you signing the will, and they're basically indicating that you're over the age of 18, that you're of sound mind, and that you're voluntarily making the will, and no one's forcing you to make this will. If those signatures are notarized, it's what's called a self-proving will. So that means that when you pass away and your will goes to probate, you don't have to call any witnesses in to testify to that. It's already self-proven, so it makes the process go a lot smoother. Again, it's important to have that under New Jersey law so that you can avoid a prolonged or protracted process. Judge Toledo, if there's anything you want to add with regard to the legal requirements.
So your will should be in writing. It should include a self-proving affidavit, as Judge Brown indicated. A lot of times people say, well, I'm just going to go online. I'm going to go on Google and look up some form, and that's going to be my last will and testament. That could work or not. One of the most common mistakes we see is the lack of the self-proving affidavit. So what does that mean? Before the self-proving affidavit existed, your two witnesses would sign your will, and then when you die, and your will is around for 10, 15, 20 years, sometimes longer than that. By the time we get to probating your will, who knows where those witnesses are? Your neighbor who's relocated across the country. Maybe it was your great grandma who has since passed away. So chasing witnesses is not an easy thing. And now you're creating legal hurdles, and by legal hurdles, what that translates into is expensive legal findings, legal determinations that you have to get made. So you're creating legal hurdles. So when you have a self-proving affidavit, we don't have to chase after witnesses. When we chase after witnesses, we bring them in, or we have them fill out a certification affidavit saying, yes, I saw Aunt Mabel when she wrote the will. Yes, she was of sound mind. Yes, nobody was forcing her to do it, right? So you're being deposed, you're being asked questions, and you're swearing to it. With a self-proving affidavit, you're getting ahead of those questions, and they're answering them at the moment that it happened. When I saw her, she knew what she was doing. And they signed to that. We don't have to chase after witnesses, so it makes things a little bit easier. It does have to be in writing. It should not be in handwriting. You'll see in movies that people write a will or make a will, draft a will on the back of a cocktail napkin. It could happen like that, but instead of coming through the surrogates court, which is a court of no contest, it's really I make a finding based on legal requirements of your will. But when it's on a cocktail napkin, written, in pen, then what happens is I relinquish jurisdiction. It goes to the state superior court. Remember, I'm on the county level. And in order to show cause, you have to file a complaint so that the court can get testimony, can hear evidence, can make a determination. Well, was Johnny sane? Was he drunk? Was he sober when he made this will? Did he mean this cocktail napkin to be his will? And again, it translates into dollars. It becomes an expensive process for you when all you should have done was just pay for the will. So where people try and save a few dollars by using the internet or by using a cocktail napkin, that kind of turns into penny wise and pound foolish. Sometimes it's better to have no will than to have a makeshift will on a cocktail napkin or through Google, because you're creating more legal obstacles.
So some other considerations in terms of the will, storing it, safekeeping. I mean, I always tell my clients there should only be one original will. Some people like to make copies, and they think that if the original will is lost, that it's okay for the copy, but no, the surrogate's office needs the original will. So I tell them to keep it in a safe place, safe deposit box, tell someone, particularly the executor, where it is. And I also encourage them to do a letter of instruction. And that letter will basically list where all of your important documents are, where you place them, your will, insurance policy, burial arrangements, any, important document. I tell them to do a letter of instruction, and we can provide them with the form where it tells your loved ones where everything is, because you know how many times family members are in crisis and they can't find anything. They don't know if grandma ever had a will. They don't know where the insurance policies are. So a letter of instruction is very helpful, and telling someone where that is, and possibly putting that also in the safe deposit box along with your will and your other important documents. We talked about updating beneficiaries. Same thing with regard to your will. You should review your will every 3 to 5 years. And you should also definitely look at your will when there are major changes in your family, when you get divorced, when there are additional children that are born, when you get married, when other people, maybe someone you named as your executor passes away, or another beneficiary under the will. So you should periodically look at your will and see whether or not it needs to be updated. So that's very important. Anything, Judge Toledo or Connie, want to add to that?
If you name your spouse as your beneficiary in your will, and when they're your spouse at the time, and you get divorced, the presumption in the law, and this even is included in designated beneficiaries in a life insurance policy. So if you become ex-spouses by the time that you pass away, the law will presume that you just forgot to get around to taking them off, which is probably true 99% of the time. I do know of a case where there were ex-spouses, listen, they loved each other till the end. He actually just passed away about a month ago. They loved each other to the end. They couldn't live under the same roof. And he was somebody that was aware that if he wanted to include his ex-wife in his will, he had to draft a will after the divorce, recognizing that she was his ex-wife, but that he still wanted her to take. This was no accident. He wanted her to take. But if she was only included before the divorce, and then they subsequently get divorced, she won't take. So, you know, take from that what you will, but keep that in mind.
Great. Thank you. What happens when you pass away and don't have a will? I'll turn this over to our surrogate who can talk about that process.
People sound so sad and uncomfortable when I say to them, well, was there a will? Was there not a will? They say, oh, no. Listen, it's not the be all end all. In New Jersey, as I said, it's user friendly. It's important to have a will, most important when you have a blended family, right? Because when you have a blended family, you have children from this family, children from a previous relationship. Sometimes it becomes an issue of whoever dies first, their original children may somehow get left out in the cold. So when you have a blended family, so very important. If you have a nuclear family, the laws of intestate succession pretty much take care of everything. So what does that mean? If I pass away and I have a nuclear family, so it's me and my husband, I've had the one marriage, I only have 2 children. So if I pass away, everything will go to my husband and only my husband. He gets everything. And then when the thought is we have to take care of spouses, you know, you're in a joint venture together, it's called marriage, until they die, he's got to be self-supporting. And then once he dies, whatever's left over will go to the kids automatically, either by law of intestate succession. Intestate means you have no will. Succession means it goes, you know, down the line, down the family line. When you have a blended family, it gets more complicated. When you have no children, it gets more complicated. And I shall give you an example on why updating a will is so important and what's the difference when you don't have a will at all. I have the couple. This file is on my desk as we speak. She left everything to him. He left everything to her. It's called a sweetheart will. She passes away. They had no children. They each had 1 sibling. The estate was worth $700,000. She passed away. She leaves everything to him. His will left everything to her, except she was already gone. He passes away a year later. His beneficiary becomes his sister, except she had a sister too, and there was no allowances made for that. So now his sister gets enriched $700,000, her sister gets nothing. So you do have to consider all possibilities when you make a will. If you have no will, it'll pass by the laws of intestate succession, but there's an additional problem. Or hurdle, let's call it a hurdle. The hurdle is that you have to apply for a surety bond, an insurance policy, because we don't have the person who passed away, the decedent, telling us, I trust Mary Smith to execute my wishes. Basically, if you have 4 kids, they figure it out amongst themselves. One of them served, but we want to make sure that they're insured so that they do the right thing. So that if they don't do the right thing, there's an insurance policy where the other 3 can make a claim against. Now, it's not free money. The other 3 will make a claim against. Maybe they'll get the money, maybe they won't. But let's say they get the money. It's kind of like a bail bond. When, you know, bail bonds existed in New Jersey, 2 big burly guys will show up to your house and find out why you breached your fiduciary duty, why you didn't do what you were supposed to when you were supposed to be distributing assets because they want their money. So the problem with getting a bond is it's an insurance policy. So you have to pay it every year. And more importantly, you have to qualify to get it. You have to have a certain level of credit. You have to have a clean criminal history. If you don't, you have a lot of explaining to do. And even if you have a good explanation, in some instances, you can't get bonded. You are unbondable. And now you're stuck with either having an attorney appointed to do it, an outsider in your business, and do you really want a third party in your business when it's something you and your siblings can probably work out amongst yourself? So that's what happens. Your assets don't get stuck in limbo, but you're going to have to decide amongst yourselves. Sometimes what happens, you have the 4 kids, child number 1 applies, number 2 and 3 agree, and what do you think happens with number 4? Child number 4 objects. Child number 4 always objects. So it can cause a delay and cause for there to be a court application, a superior court application, which delays the process. Ms. McGee?
I'm good. Thank you.
Okay. power of attorney, we have a picture of Connie McGee's father, Charles Bentley, a World War II veteran who is
Whoa,
100
whoa.
years young. And Connie wants to share with us the importance of a power of attorney and what a power of attorney does.
Well, it all boils down to family, the way I see it. And I thought my dad was a perfect person to have here. This picture was taken a couple of days ago, right after he got his COVID-19 vaccine in Indianapolis. And I talk about that because obviously at 100, Daddy could have had it months ago. So flashback to siblings and this one having a power of whatever health needs he needs, and everybody else arguing about does he get the vaccine or doesn't he? And so siblings were split. And because of that, it's like no decision was made. Meanwhile, everybody's swirling around him. Finally, his doctor said, I think he really should get it. And still there was pushback. So even with the power from a durable power of attorney, he still didn't have the COVID vaccine. And ultimately, about a month ago, he was able to get the appointment and he had his shot. Today is Wednesday. I think it was Monday. But I talk about that because often people think that with the power of attorney, they can do whatever it is they want to do on behalf of someone. But actually, you do what that person wants you to do. If you have the durable power of attorney, that does give you the authority to act on someone's behalf when they're no longer capable of carrying out their own wishes. And this, to me, this is more powerful than a will. I kid you not. It's while the person's living, you actually are trusted and have the authority to care for them in a way that they could never care for themselves. And I just think that's so important. And but in every aspect, real estate, your attorney could have a limited power of attorney to handle the closing while you're off on vacation. Or unfortunately, a friend or a relative goes off to jail. They need somebody to handle their business. So it could be for any number of reasons that you're given this power of attorney. But I always think of it as something that we really honor, that we actually have, and that we've been entrusted to care for someone. And so that's why I put Daddy up there.
Thank you, Connie, for sharing. But it's one of the most important documents, and it's the cheapest and easiest thing to do. A lot of times people don't think about a power of attorney until the person is already incapacitated. And then everybody's running around trying to figure out what to do. No one can speak to the doctor and participate in that person's care when they're incapacitated because they have no power of attorney, no health care power of attorney, which we'll talk about in a few minutes. You can't go to the bank, do any banking for them. You can't pay their bills. You can't do anything. If you wait too late, now you've got to actually go to the Chancery Court and file for a guardianship, which is a costly, lengthy process, and the court has to declare that person incompetent when all you had to do was, when that person was sane and of sound mind, do a power of attorney that would give you the ability to handle their affairs financially, legally, and I also sometimes write healthcare language as well, and the power of attorney that will give you access to records, give you the right to talk to doctors, and it's a very, very easy process that will help you avoid a lot of headaches and will save you a lot of money in the long haul. So speaking of power of attorneys, let's talk about the healthcare, advanced healthcare directives. There's two kinds. There's a what they call a proxy directive or a durable power of attorney for healthcare. And this power of attorney, you're designating someone to act on your behalf to make medical decisions for you. You should choose someone you trust, but you should also make sure that you have a conversation with that person and they're well aware of what your wishes are in certain situations. So be very, very careful when you're designating someone to be your power of attorney for healthcare. And that can be a general power of attorney where they're making healthcare decisions for you in the event that you're not able to make them. But you also have what's called a living will or an instruction directive, which is a combination of instructions as well as power of attorney designating that person as your healthcare representative. In the living will, not only are you designating the person as your healthcare representative, but you are also providing specific instructions as to what you want done in certain health situations when you are incapacitated. Do you want artificially provided fluids and nutrition, otherwise known as a feeding tube? Do you want them to administer CPR? So what do you want done in certain situations? Families struggle all the time when they get into these situations. Do we disconnect the breathing machine or not? Do we continue with them on a feeding tube or not? What better way to ease your burden than to have a specific living will that lays out all of these situations and what you want done? So there is no doubt, there's no question. And the family, while having to make hard decisions, at least they will know that they are making decisions that you would want carried out. Another thing that you can do in an advance directive, living will, is you can indicate whether or not you want your organs donated. Again, these are very important estate planning documents that I believe that everyone should have in place. And I think it will make your lives easier as well as ease the burden on your family members. At this time, I wanted to at least spend some time answering questions that people may have. There's a question in the chat. I co-own a home with an older family member. What happens if she transitions before me and doesn't have a will?
If she transitions before you and she doesn't have a will, then her heirs, her next of kin, will have to make an application to the court to see who will be appointed for her part. But then what's going to happen is you're either going to have to buy them out at market value or sell the house and split the proceeds, but only half of that house is yours. The other half will belong to the older family member or their heirs. If they have 1, 2, 3 children, that's okay, but let's pretend that they have 3 children. One of them, the oldest one, predeceases, and he has 4 children, and one of them married and divorced or whatever. That's when it starts getting complicated, because you have a lot of people, you get a lot of cooks in the kitchen who have to give an opinion or who have to, the word is renounce, and they have to consent in favor of the person making the application. So you start getting further away in generations and it gets problematic. So my first word of advice, especially in something like that, where it's a blended arrangement, you should encourage the older family member to have a will. But if they don't have a will, somebody's going to have to make an application for their half of the estate. But when you go to sell that house, if that's not settled, you will have a cloud on your title and you may lose a buyer.
Thank you. Another question in the chat. What happens if the next of kin or successor of the deceased is mentally ill? Now, are you talking about if the deceased does not have a will? I'm assuming you're talking about someone that died intestate and their next of kin is mentally ill.
Let's talk about somebody who is, we call that a person who is incapacitated. So the question is, are they adjudicated incapacitated or not? Because if they have been adjudicated incapacitated, that means there wasn't a power of attorney. Let's say they had Alzheimer's, but and they didn't have a power of attorney in place, so they had to have a guardianship. So if somebody passes away, they have no will, they have 3 children, the 3rd child is an adult with Alzheimer's who's incapacitated, and they have a guardian, well, that's not a big deal. The guardian just steps in and does what guardians do. They will either renounce in favor of the applicant, the first person, let's say the first child was the applicant, they renounce in favor of the applicant, or they object or whatever, but they're standing in the shoes of the person who is incapacitated. And I use that as a legal term of art. In other words, they were adjudicated. A judge said this person does not have the capacity. Now, what happens if you have a person who's incapacitated, but there's never been a finding in a court? now you can have a problem. This is when what Judge Brown was talking about, a power of attorney is so important. So you have a power of attorney. That power of attorney should have the words durable, right? Because durable means when you have a power of attorney, it means, well, I give the power to Ms. McGee to handle my affairs. Well, you know, I go winters to Florida. I'm a snowbird. She can handle my affairs. But the idea is I have my capacity. I'm looking at my bank statements. I'm sort of supervising it, even from a distance. I just don't want to come to New Jersey in the cold and do my stuff. Fine. When it's a durable power of attorney, that means even if the Alzheimer's strikes and I subsequently can't supervise Miss McGee, even if I, you know, you see in soap operas, everybody gets amnesia. Even if I get amnesia and forget everything, the power of attorney is durable. It lasts. But if you didn't have that power of attorney, somebody passes away, you know, somebody has passed away and you are the next of kin that would inherit, and you haven't been adjudicated and incapacitated, you have just added another layer of delay, cost, complexity. I can't emphasize enough in that instance how important it would be to have a power of attorney, to have a will, to have these documents that Judge Brown is talking about. The amount of money and delay that you're going to add to your life is going to be just cumbersome. It really is. It can be done, but it'll take a while.
And I just want to make one comment in terms of power of attorneys, because people make this mistake all the time. A power of attorney is only valid while the person is alive.
Correct.
Once that person passes away, the power of attorney dies with the person. That is when the will steps in. So people sometimes believe because they had the power of attorney when the person was alive, that when they died, that now they can use that power of attorney to make decisions or access accounts. Not the case. The power of attorney dies with the person. So just remember that. Connie, did you had something you wanted to add before we get to the next
No,
question?
I'm good. That's so true. Correct.
Okay, great. So we have another question in the chat. Through my job, I have life insurance and a 401k. It is a requirement to have beneficiaries. I also have that healthcare directive and living will. Do I still need an estate will?
Those are the assets that Judge Brown was discussing that pass outside of the estate. So your designated beneficiaries on your 401k, your IRA, whatever it is that you have, if there's a beneficiary, it passes to whoever's named. If by the time you pass, that person has predeceased, it will go to their heirs. You could designate your estate to be the designated beneficiary, and it will pass. If those are your only assets, do you need a will? And I guess you don't need a will. Those assets will pass. Should you have a will? Well, I mean, sure, you should have a will, just because if you have a will and there are no probatable assets and you don't need to probate, I mean, that's fine, but it's better to have it and not need it than to need it and not have it. And one example I can think of is a wrongful death action. Let's say you have no asset. Let's say the assets are only like the ones you named with the designated beneficiary. But you suffered a wrongful death. Now somebody has to jump into your shoes for, it's called an administration, related to a wrongful death. An administration, I'll use a fancy word, ad prosequendum. This is complicated stuff. I'm trying to not make it too much to handle, but an administration with relation to a wrongful death. Now you've added an extra hurdle. So should you have a will? Sure. Listen, maybe you'll never need it, but it's better to have.
So we're going to take one last question from the chat. What if my child was left some money payable on death from her pop and did not receive it yet?
Ms. McGee, Judge Brown, me?
So I'm assuming this is a bank account of some sort that was payable on death and the child was named, but they haven't received it yet. So I don't know what recourse they would have to take to get the money.
I'm not sure exactly the details of the question, but let me explain to you what happens when a child inherits. Any amount over, or not just inherits, or receives a civil award. So I safeguard $20+ million that belongs to different children in Passaic County. I'm safeguarding this money because they have either inherited it from their pops, they have inherited it from family members that have loved them, or they have suffered some sort of damage that resulted in a civil award, a lawsuit. So I hold this money. Anything over $5,000 will not go directly into the child's pocket. It will go into one of two places: a trust established for that purpose, or it will go into the surrogate courts, that's me, trust fund. So I have this trust fund, I safeguard the money. The money stays there until the child is 18 years old, barring an extraordinary expense. So what is an extraordinary expense? Well, you can't petition the court to take out, let's say your child has $100,000, you can't petition the court for groceries or for rent money. But let's say they're graduating from high school and they need the prom dress or some college application fees. Okay. Let's say they want to see their grandmom who lives in the Caribbean and they haven't seen her in a few years. Okay, well, maybe grandma and maybe the child is going to go there, but he needs, a guardian or somebody to watch, or a chaperone, let's say. That's fine too. But the child's not going to pay for the chaperone, the brother, the sister. It's not going to pay for the family vacation. We will put a stop to that. I put a stop to that because my job is to make sure that that money is going to be there when that child turns 18 for the purpose of college, car insurance, whatever it is that they want, but it is their money. Sometimes parents think that, okay, well, my child received $100,000 in a lawsuit, we can use it to buy a house for the betterment of everybody. It's not going to happen. We hold it. So before I answer your question, we have to figure out where that money might be. Is it still in the bank account? Was it put in trust, or is it in the surrogate's court? If it's in the Passaic County Surrogate's Court, I have it. It's not going anywhere. I've been safeguarding money for 10 years now, and we have it until your child turns 18.
Okay, well, our time is up. We probably went significantly over our time, but I do want to take this opportunity to thank our panelists. Thank you, Judge Toledo. Thank you, Connie Bentley McGee. I also want to thank Reverend Dr. Joel Rudolph Sr. I want to thank Ms. Arnez Crockett. I want to thank the leadership team of the LITE Community Development Corporation. I want to thank all of the members of Christian Fellowship Center and Outreach. I want to thank all of friends, family members, everyone that has joined us tonight. I'm glad that you were able to join us in this discussion. As I stated in the beginning, we know that death, dying, and our own incapacity are very difficult, subjects to discuss with others, as well as having a conversation with ourselves. But the time to think about this is not as it is happening. The time to think about this and discuss and plan for the inevitable is now. So I truly hope that after tonight, you each will have the comfort level and the confidence, and I hope that you're inspired to move forward, to get your affairs in order and put together an estate plan. Thank you all, and have a good night.
Thank you.
Thank you.